Thank you, madam. Thank you. Good evening to all. I'm happy to associate with the one-day international webinar on territorial disputes in international law, effects and consequences, organized by my good old friend, Dr. Venugopal, head of the Department of Law, and Dr. Rajshekhar, and the most revered President of the Court of Appeal of Sri Lanka, who participated in the inaugural, and also my colleague and the Vice Chancellor of Madras University, Professor Gauri, and another colleague and Vice Chancellor of Gujarat National Law University, Professor Shantakumar, my good old friend again, and many of my friends and teachers, ladies and gentlemen. I'm very extremely happy that Dr. Venugopal has chosen a very contemporary area, the very most important area, pertinent area. Well, speakers might have spoken a lot length. I couldn't continue the entire session because of due to heavy pressure of work. But since the love and affection that Venugopal has, he requested me. Then I said, okay, I'll speak for your sake. Definitely, I will come and talk for a few minutes, because right now I'm busy with serious meetings are going on. But anyhow, let me come to the issue of the subject. Well, territorial disputes or border disputes is a very important subtle area in international law, which is in existence since long. It's of different dimensions. The dimensional perspectives of the territorial disputes are very important because in the ancient periods, even in Eastern perspective or Western perspective, they have been settled by employing the methods of pacific settlement of disputes. That's what in municipal law today we call as alternative dispute resolution. In international law, it is very old concept, and particularly in Indian law, it is the much more old concept. Right from ancient periods, it is there that we have to settle the disputes peacefully, particularly territorial disputes. If we don't settle the territorial disputes peacefully, it will affect the country and the progress and the economy of not only one country, but of the region, but of internationally, it will bring in a lot of problems. Today, there are multi-number of territorial disputes are in existence in the world. Right now, we are facing problem with China on one side. Recently, the tiny country Sri Lanka started raising, Nepal started raising one issue. Sri Lanka, we have a maritime border dispute since long. And Maldives, we have a dispute. Pakistan, never-ending dispute, they won't be satisfied. Why all these disputes are coming? We have to blame our territorial masters. The territorial masters never settled the disputes properly, nor territories divided geographically as per the principles of international law. Because it was taught by the territorial masters that whatever lines that they draw, they will settle forever, otherwise they ruffle. This is what we are witnessing in Africa. The border disputes are continuous perennial issues in international law. Well, we have number of cases that have come before the courts, number of issues. The most leading case was the Cambodian case, the Temple of Preach Vihar's case, where it has been settled. But many students of international law should think that the Temple of Preach Vihar is settled by the International Court of Justice long back. So that is a settled principle under customary international law. So occupation is a very important principle. But again, 5 years back, it has come for a review. So the Temple of Preach Vihar case has again surmounted the dispute further dealing with the various aspects. Well, we have disputes on land, we have disputes on air, we have disputes on sea. Everywhere we have disputes. But this is what boundary dispute. When we go into boundary, it is only land disputes, which we are right now fighting. Yesterday also we had a fight with China. 92, China has occupied many of the territories which the internal government of India has not objected to it. We were weak. Today we are not weak. So today we are resisting because we have also developed over a period of time. So this leads to various other important aspects. Now, territorial disputes arise apart from treaties, custom, whatever the other sources that we have, mainly treaties. Unfortunately, like state succession, another important area which many people forget is the root cause for many of the territorial disputes. This is a very important area, particularly in 90s, when Yugoslavia, Czechoslovakia settled issue. Yugoslavia to certain extent settled issue. Russia not settled. Because the Russian Federation has been broken into pieces. 22 states. Then the issue is with the Balkan Sea and the Black Sea area, particularly Russia with its territories, is a perennial issue. Now Russia is facing a problem. Now America, with Mexico for constructing the wall, now America is again raising the issue. European Union appears to be settled the boundary border disputes, but not fully settled. Now, what the principle that we have to do is the uti possidetis doctrine, which is the oldest doctrine inherited from Roman law. Many of the international textbooks say uti possidetis doctrine is a Roman law doctrine. Even Oppenheim says it is a Roman law doctrine because it is taken by the father of international law, Hugo Grotius, from the uti possidetis principle. Uti possidetis, if we examine clearly, is much more older than Roman law in India. It is a very older principle that has been there even from the Vedic period. Established principles have been there into various aspects. In Arthashastra, if we look into the Kautilya's Arthashastra, he has clearly demarcated how a territory has to be disputed. And how a territory has to be demarcated has been clearly laid down, and those principles have been re-enunciated during the period of Akbar. We don't read, unfortunately. We have a rich library in the same Madras University where Professor Ramarao and others built a rich library. Is the territorial disputes. So, territorial disputes are a very, very, very pertinent aspect that has been done. But recently, by the delimiting of the boundary disputes, like North Sea continental shelf cases. Well, North Sea continental shelf cases have given us a tip of iceberg, because the International Court of Justice has said it is better the parties settle among yourselves. ICJ has not drawn any perspective with respect to maritime territorial disputes are considered. When that is the case in maritime territorial disputes, okay, we can understand there is a lot of property and others. What is there in land territorial disputes? Land territorial disputes also, you have properties. Like Nepal, which started claiming, which is not its own, now claiming an Indian territory as its territory. How dare it is to do it, people who settled. So what their nationality, their culture, cultural perspective, everything is to be ruffled. Then do we have to wage a war only all the time? Should we go for warring principles? So, it affects cultural perspective, cultural relation, cultural identity, ethnicity. These are the issues that are closely related to one's heart are affected if territorial disputes are not settled. Is it not the responsibility of the states to address these concerns? Unfortunately, the law of state responsibility codified by the International Law Commission has not been accepted by the states. Same is the case with state succession. These are the two major areas are uncodified today. If we codify these two areas, majority of the issues will be settled. But states are not interested to settle these areas. But right. So the territorial conclusions that now, when there is no codification is considered, what is the methodology that is adopted in the modern context? In the modern context, critical border disputes is the concept that is emerging. This is an emerging concept. If we look at the judgments of the International Court of Justice, right from 80 to now, there are about 20-25 cases have been decided by the International Court of Justice. Malta, Arabia, or Abbey area dispute. Abbey area is a very important dispute. If we read the Abbey area's judgment, the court has clearly highlighted the various principles with respect to various issues. So the tripartite methods that are advocated, treaties, colonial conclusions, effective control, all have employed, all have been failed. So now the critical border dispute settlement mechanism again reiterates mediation. Mediation is arbitration cannot settle anything. Arbitration is a failed mission. We only think in municipal law, arbitration, arbitration, arbitration. Thanks to Bar Council of India, it realized now that introduce mediation from this year. Mediation is the best method because it leads to critical perspective of involving the parties together, bring them to the negotiating table to deal with, as India, China is now doing for the last 1 month in the mediation. One side mediation is going on, one side dispute is going on. But anyhow, the major towers of dispute can be avoided only by employing mediatory perspective, which is judicial settlement, war, that is all a foregone conclusion. Treaties will not have any effect. Because if we look into treaties also, Jescogen's principle is there in treaties. If we go into the Jescogen's, Brownlee talks of the contemporary various other perspectives. So if we look at treaty border perspective, Professor B.S. Murthy long back has written the very important significant perspective of mediatory perspective, which is now gaining currency by the International Court of Justice. So the new jurisprudence that is being advocated by the Abbey arbitration, which has been taken into consideration by the Permanent Court of Arbitration, uses on the sidelines that it is for the people to do the choice, whether you want to be the administrative perspective coincide with that or this. Like what now the government of India is saying that the occupied Kashmir, be okay, occupied Kashmir. You decide under this and deal with it. Let me just thwart that in 2 minutes. I won't take much time because already 6:30 people are waiting. In Kashmir issue also, we have wrongly interpreted the provisions of the instrument of accession. Everybody says the instrument of accession, as said, acquire the confidence out of the people. Where it said, instrument of accession, nowhere has mentioned the will of the people to be assigned. Nowhere. Instrument of accession entered by 560 states, by Kashmir also say. It was Lord Mountbatten who has written. It was Lord Mountbatten's view, which is not part of the treaty, which is not part of the instrument of taxation. Very clear. Because now the case is going on in Supreme Court. We have to analyze the legal perspective because we don't know what outcome it will come. Because we have to understand the issue. When I was talking to the Attorney General of India, K.K. Venugopal sir, he was also asking the status of, I said, sir, it is ridiculous. And thanks to K.K. Venugopal sir, I had at least 1.5 hours discussion with him. And he said, you send me your book. I sent it. And he said, it's most authoritative. I will use it in the court also. Thanks to him. Very clearly, the legal perception, Justice A. Sanam, the former Chief Justice of India, who did his PhD on this area, on the status of Kashmir in international law, on the constitution of Kashmir in international law. The status of Kashmir in international law is clearly part of India. Unfortunately, the Jammu Kashmir High Court in 1960 said that the sovereigns, the Kashmir king has got independence, so it is an independent. Never and never they had independence. Before the British came, in the ancient periods, these princely states were part of hereditary kings to somebody or other. Later, to the emperor, that is the Muslim period, later to the British. Then they got independence. And the 1947, the Indian Independence Agreement, if we read, we only read Section 7, Class 2, that paramountcy is foregone conclusion. So they became autonomous or independent. Paramountcy is replaced. Basing on paramountcy only we argue, but we don't read the subsequent orders passed by the British government of India. Properties order and the devolution of territorial orders and other orders passed by makes it very, very, very specific that these territories which are joined with Pakistan, joined with India, definitely have to enter into treaties, to enter into the, if we look into the properties order of 1947, we don't examine properties order. 1947 Rights and Properties Order of British government, if we examine, read together with Indian Independence Act, it makes it very, very, very specific that these territories cannot be given independence. They have to join either one territory or other, because in the properties order, it stated while devolving the properties to settle the property disputes, the states have to join with one territory or other. Very clearly written in the properties order. We don't read. Half knowledge is dangerous in international law. Half knowledge is dangerous. We have to read fully. And the one of the Chief Justice of India, Justice I think Chavan, has also made it very clear that it is no more a part of ascertaining the will of the plebiscite. Is not there in Kashmir issue. By plebiscite which is not there, where do you get? It is government of India told we will conduct ascertain the will of the people in UN. Where are you to go to UN and talk when your own law is very clear? Land law is very clear. So, border disputes are complicated by personal interpretations, misinterpretations, treaty provisions by the states. So this is all the tripartite perspective of colonial perspective, customary perspective, or treaty perspective is complicated. Hence, the arbitration, Court of Arbitration in Abbey has made it very clear that the Sudanese people have been given the right to join either this administrative territory, that administrative territory, which again brings back the cultural perspective of critical border dispute studies. This is the area that is developing now, that is mediatory perspective with conciliatory tone that you have to settle. That is negotiation, mediation, conciliation. These three, particularly negotiation and mediation, are very important. And if we ascertain these aspects, taking into impact of the community relations, balancing the issues of economic, socio-cultural perspectives, definitely there are ample chances for settling territorial disputes between the states, and the critical border studies of states are a very important issue which needs to be examined and to be highlighted. Will be the only solution to settle the issues for which the states have to come wholeheartedly with the negotiating, mediatory, conciliatory perspective and arbitration or judicial settlement or not. There are foregone conclusions which have been failed. If we look into law of treaties or if we look at various other perspectives, because as long as state responsibility and state succession are not codified, whatever method we use, territorial disputes will come, territorial disputes will be there. So as long as nation states are there, territorial disputes will be there. There are about 250 disputes are there right now. It is not a parliament which passes a law like India, but overnight I divide one state. Well, parliament has the right. At least the constitution has given the right to parliament. So they divided Andhra Pradesh midnight. Tomorrow they may divide Madhya Pradesh or UP, Bihar, Tamil Nadu, Karnataka, Kashmir recently. 370 remote made it. Well, Parliament has the right internally, but internationally we don't have. So we have to go by the Committee of Nations by using the critical border studies mechanism as set by the Abbey jurisdiction, Abbey case, and deal with respect to negotiation and mediation, which are the important perspectives. Max Sorensen, in his settlement of in his international book, where Professor V.S. Murthy has dealt Pacific settlement of disputes extensively. Today, Pacific settlement of disputes has become a very important area, particularly in addressing territorial disputes. I'm extremely happy that Dr. Venugopal has chosen a very, very pertinent area. It may look, for people, it is a settled area. It's a never-ending, never settled area. I am extremely happy. I have only raised some issues. I have not drawn any conclusions. Now I request and appeal that in these grounds, we have to re-examine. Maybe I request Venugopal that by bringing a very important issue, take some 5 to 6 months time, collect good papers and bring an excellent proceedings, which will be eye-opening to address the critical border dispute studies from a different angle that is developing. Of course, it is not a new concept, but old concept resurfacing and remounting with the various aspects. And I'm thankful to Venugopal, Rajshekhar and other colleagues for patient listening. Thank you, one and all. Thank you.